Thank you, Mr. Chair. I rise in opposition to this bill. So let's talk a little bit about presidential executive orders. There are two types of what's called a Article 1 executive order, and that is when Congress has delegated to the president the authority in a particular area. And then there's an Article 2 executive order, and that's issued pursuant to the president's power in Article 2 to take care that the laws be faithfully executed. Executive orders have been used by every president but one since George Washington. President Trump issued 220 of them on the high end for one term, but not the highest. The most important thing about executive orders to know is that they have the same effect as an act of Congress as it pertains to the Supremacy Clause and the states. That was decided a good while back in the case called Old Dominion, and that remains the law. So what this bill does is, first of all, in Section 1, it says that the Attorney General can review a law, and if there's a problem with it, an executive order, and if he finds that it exceeds the president's authority or that it violates the Constitution, he can go to court with that. And that's always been the case, and that's fine. It's happened many times, and it will continue to happen. But what Section 2 does is something quite extraordinary. It gives the Attorney General the power, the Montana Attorney General, the power to declare a state law, a federal law, in the form of an executive order unconstitutional, and declare that we're not going to follow it. Now, there's a name for that, and it's called nullification, when a state, through its officer, declares that it won't follow federal law. It was used for the first time in 1836 by the state of South Carolina. There was a federal tariff. The state felt that it was unconstitutional and didn't want to enforce it, and they said they weren't going to do it. And so President Jackson at the time issued the following statement. He says, "I consider then the power to annul a law of the United States assumed by one state, incompatible with the existence of the Union, contradicted expressly by the letter of the Constitution, unauthorized by its spirit, inconsistent with every principle on which it was founded, and destructive of the great object for which it was formed." Congress then threatened the use of military force against South Carolina, and a few years later, South Carolina withdrew from the Union, seceded. And then it wasn't used again, or tried to be used, until the 1950s, when southern states attempted to use nullification to prevent integration of their schools. Their claim also was that we don't have to follow federal law or federal executive orders. These attempts failed when the Supreme Court again rejected this theory in Cooper versus Aaron, expressly holding that the states may not nullify federal law. In those cases, the Supreme Court called this idea of nullification a, quote, totally discredited theory.
1 minute.
Friends, this is a dangerous bill. We are a nation of laws. We are held together by the law that binds us all. If each state gets to decide which federal law they'll follow or not, we no longer will be a nation of laws. We no longer will be a republic. Indeed, we'll no longer be a nation. Please vote no on this clearly unconstitutional bill. Thank you, Mr. Chair.
Staffman, I'm obviously not an attorney, but in Section 1 of this sort of makes sense to me that one might have some concern about executive orders and want to review them and determine their constitutionality. But as a layperson, Section 2 makes no sense to me, because it says the Attorney General determines to be unconstitutional, but I was under the understanding that's a court process. Could you correct me if I'm wrong?
Mr. Chair, good representative, yes, thank you, you're exactly right. The courts have decided that under the Supremacy Clause of the Constitution, not only does federal law trump state law when there's a conflict, but that the federal judiciary under Article 3 has the final power to interpret the Constitution. So the purpose of the bill is to allow the state of Montana to challenge the constitutionality or the authority of an executive order, and that's fine. We have a process for that. It's been done hundreds of times by not only our Attorney General, but Attorney Generals of most every state. Sometimes they band together in order to do this. And they go to court and they challenge it. And that is the process. And that is a good process. It's worked since the founding of our nation. But this is a radical departure from that process. And while it is true, as the good representative on the other side said, that there was talk about this by Madison, even in the original Federalist Papers, the courts ever since then have consistently rejected this theory that was advanced by Madison at that time without any hesitation, calling it a discredited theory. There's no state that has successfully ever used nullification to overrule a federal law. We have a process for it. It's in the courts. Our Attorney General can do that. He's done it before. And we're part of a union. We're not a renegade state like South Carolina was in 1836, leading to its secession. Thank you. Thank you for the question, Representative.